Okay, welcome to another episode of Justice for Y'all. I'm Paul Painter, and here as always is Andrew Bowen and Stephen Morrison. Guys, how's it going?
Not too shabby.
Doing fine. Ready to get this podcast. Let's go.
Cast these pods. That's what we're doing.
It's a beautiful Friday afternoon.
That's right. We try to cast our pods on Friday afternoon. Good segue to the weekend, you know?
That's right.
Yeah.
We're loosened up, ready to roll.
It's not just because of the bourbon.
No, it's an important part of our team.
That's right. That's right. It lubricates the mind.
Everyone has a part to play.
I know we were kind of casting around ideas of what to talk about. And Stephen, you've got you are actually president of the Federal Bar Association right now.
You're tuned into the podcast where justice meets Southern hospitality. Broadcasting directly from Savannah, Georgia, join your hosts, Paul, Stephen, and Andrew of Bowen Painter Trial Lawyers as they chat about the legal difficulties you might face in everyday life. From the ports of Savannah to the busy highways that stretch through the southeast, we're your go-to source for all things legal. Served up with a dose of Southern charm and commitment to justice for y'all.
The Savannah chapter, yes.
Savannah chapter.
Yeah.
And you're organizing a CLE on Maritime and Admiralty Law. So I want to ask you a little bit about that. But first, what is the Federal Bar Association?
I am so glad you asked that. The Federal Bar Association is the voice of the federal bar and bench. And I get to give this sort of talk a lot now that I'm the president. And I can't say enough good things about the Federal Bar Association. Essentially what we do is we provide a forum for folks who practice in federal court, not just exclusively in federal court, but anyone who finds their practice brings them into federal court. So we have everybody from patent lawyers to just general litigation, commercial litigation, disputes between companies. You get into federal court most often in civil cases through either a federal statute, so like a civil rights case, employment, things like that, or two citizens of different states suing each other, where you are involved in litigation with the federal government. My background has come from being a federal law clerk and then working as an assistant U.S. attorney. And now we get some cases every now and then where we get what we call diversity of citizenship. Two folks from different states sue each other. Instead of one of them getting home cooked and the other's home field of state court, federal law has long allowed defendants to remove cases to federal court where they feel like they might get a better shake. But the Federal Bar Association is for folks who find themselves practicing in federal court. We have judges, government lawyers, practitioners, and it's an educational institution. We provide civics education to non-Federal Bar Association members, and we also have it's a good collegiate place for adversaries, co-counsels, and judges to all get together in somewhere besides the courtroom. And we find that provides a lot of benefit for the practice professionally. If you know somebody outside of the courtroom, it's a lot less easy to send that snippy email. Although maybe if you know them well enough, you send it anyway. And then the other big thing that we do is advocacy for the Federal Bar Association. Or for the federal bench, so federal judges can't lobby. We do that for them. We have an event once a year in Capitol Hill, and throughout the rest of the year, we are often interfacing with different members of typically Congress, but sometimes others in different agencies on behalf of the federal bench for things that matter to them, like judicial security, additional judgeships, things like that.
Okay. And we're also sitting here with the immediate past president of the local chapter of the Federal Bar Association, Mr. Paul Painter.
Yes, I tried to run into the ground, but Stephen managed to bring it back, so there you go.
Well, like I said, we each have our part to play.
And we are all members of the Federal Bar Association because while we don't practice exclusively in federal court, our practice does find us there.
It's a significant part of our practice, yeah.
And it is a significant part of our practice, but it's also something that not a lot of plaintiffs, especially injury lawyers, find themselves comfortable with. But I think all of us here, while you may have our preferences for state court for different things, but getting into federal court doesn't scare us.
No, it's got a lot more rules, and it's got a lot. You've got to just be a little tighter going into that than you do state court, and I think a lot of plaintiffs lawyers just don't feel, like you said, real comfortable with it, and wondering what rules are out there that they're going to miss, and that's something we're very familiar with.
Definitely, and being in the FBA is a big part of that. Is you get a chance to connect with the bench and other practitioners, provide tips for each other and educational events, which we've got one coming up that I'm pretty excited about. Our inaugural Southern District of Georgia Chapter Admiralty Law Seminar on November the 8th. We have the DeSoto Hotel in downtown Savannah, and we are bringing in folks all the way from Texas to Virginia, maritime practitioners. It is not exclusively for lawyers. I actually had a non-lawyer, somebody who found themselves in a coverage dispute about one of their boats, has inquired about potentially joining.
Oh, really?
Yeah, kind of. This is hot off the press, and I reminded myself and them that we are glad to have non-lawyers there too.
Yeah.
Because, everybody has an interest in this. If you are on the coast or your business involves international commerce, ports, anything like that, you may find yourself in a maritime case, or if you have a recreational boat and somebody gets hurt on that, or you get hurt, somebody else, collision. There's an interesting case in the Southern District of Georgia several years ago, actually, where a locally owned, nicer speedboat, I'm pretty sure it was, during a hurricane got loosed from its hoist on a dock and ended up down the way, trapped up between the riprap on the bank and a bunch of debris, or flotsam, as we call it, and a salvage company came by and said, hey, that boat looks like it's in distress. So they went through all this rigmarole and undertook a lot of expense to salvage that boat, then sent a bill to the owner. The owner said, I didn't ask for this. But it doesn't matter under maritime law because you are allowed to salvage a boat that is in distress. So the dispute was the boat in distress? The judge found that it was, and the person who owned the boat was required to pay the salvage company the balance of the invoice in order to get their boat back. So it's an interesting area of law, and we've got a whole conference dedicated to it coming up in November. Topics range from scintillating issues of coverage, which is way outside of my bailiwick, and especially on the transactional side. I think that these folks that get involved and put together.
So you're talking about when there's a shipment and let's say a container falls overboard, something like that.
Yeah, exactly. And drafting up those agreements between the different parties involved in the transaction, because you've got, in a maritime case, you've got the person that owns the ship, maybe you have the company that owns the ship, then you've got the person who charters the ship or who has the right to carry the goods, then you've got all the people who have loaded containers onto that ship, and then you get the people that are on the other ship that the ship collides with, the persons that are injured. You get a lot of parties, and each one of those there's a risk element. And on the company shipper side, there's often layers and layers of insurance issues and risk issues that are involved. So there'll be panels on that. Paul, you've got a panel that I'm looking forward to on sort of plaintiff's claims in that. We're doing a little history of maritime law in the Southern District. So it's going to be a good event, capped off by a nice reception at the Chatham Club afterward.
That's right.
Now, tell me this. Are all admiralty cases, maritime cases, heard in federal court as opposed to state court?
They are not. No, okay. In fact, a lot of the cases remain or start or finish in state court under a doctrine called the savings to suitors clause, which comes out of the Constitution that says basically common law rights are preserved for federal admiralty cases. So if you had a common law right to sue in state court, you still get to sue in state court, and you actually can't remove it to state court. So even though it's an admiralty jurisdiction, technically, courts, including our district court here, will send that right back to state court under the savings to suitors clause.
There's so much law about admiralty and maritime that is different than you have for
it's quirky.
The rest of the things we practice on. And part of that is I don't want to say it hadn't evolved over the years, but it hasn't evolved to the same degree, especially with legislation over the years. It just doesn't get that as much attention, perhaps, because it's a smaller area of law, but it's also...
It's so niche.
It is. I mean, even, the lawyers in there are called proctors.
Right.
Yes.
Yeah. Which I don't know where that term comes from. I mean, Andrew?
I do not know.
That was my
and if Andrew doesn't know, then no one knows.
He was there when the law was.
And speaking of Andrew being old, this is maybe the oldest body of law that is continually part of the world now. It was the oldest form of international law, certainly, because, going back, a millennia, there was ships that went from country to country in international trade. And obviously transportation and shipping on the high seas has been part of the world for, centuries. I think it even goes back to, Roman times and even Greek times, going across the Mediterranean and that kind of thing. I don't know what the very origin is. That's a little bit outside of our normal practice.
Well, that's true. I got a little bit nerdy preparing for this conference. So I've got an after lunch panel, which is always the coveted spot. So we've got to make this interesting.
Make sure. about to fall asleep.
I think that folks that are interested in maritime and admiralty law are kind of interested in the atmospherics of it, just because it's seafaring and shipping has these quirky names, proctor and admiralty. But the term admiralty and maritime are roughly interchangeable. Maritime comes from the Latin mare, the sea, but admiralty actually comes out of what they call the vice courts of admiralty, which was an English thing, and jurisdiction was given to these officers within, I think it was within the English Navy, the vice admirals, over these issues exclusively. So that's why they were called the admiralty courts, because it was these vice admirals, like admirals in the Navy, who had this military authority, but they were given jurisdiction over the particular cases as part of their title, and that's where we just, like we did with so many things, we just held on to it. And that's why we, so you hear admiralty law and maritime law, it's kind of like lawyer and attorney these days. I mean, maybe at some point there was a distinction that maybe maritime may at one point have been broader than admiralty, but as far as I can tell nowadays, you can use them both ways. And we call it an admiralty law seminar, but it's a maritime seminar if you want it to be. It's a maritime conference if you want it to be.
So let's talk about some of the things that fall under admiralty/maritime law. And it really has to do with anything that happens within the navigable waters for the United States, any navigable water for the United States. So if you can...
Or internationally.
Or internationally,
right.
But I'm just focused on certainly high seas and
right.
other countries the jurisdiction can extend. But, there gets to be some questions of, okay, if you're on a landlocked lake, are you on navigable waters? And the answer is generally no. But if you have some connection to the sea that you could, even in some tidal creek that dries up and you can't
right.
use it, or you can't, you couldn't get a ship through, you are still within the jurisdiction of maritime law.
I had a case when I was at the U.S. Attorney's Office that really had to dig in. It's for federal, I think the United States government is a pretty small area where the United States gets involved as a defendant in what's called suits in admiralty or the Public Vessels Act. We had to dig into this question, kind of like, how far does it go where the tide runs? And it really goes up to the point, as long as there is a sort of continuous connection between or interaction between the body of water and the navigable commercial lanes, then you've got a good chance at admiralty or maritime jurisdiction. Two cases that kind of, I think, show maybe the difference. One, I think it was out of Missouri. There was one of those duck boats, it's got the people like the amphibious thing, and everybody's got the little quacking, whack, whack, lip things. That one of those went out in conditions that it should not have gone out in, turned over, people got severely injured. I think maybe one or two drowned. So there was an injury case there, and they claimed admiralty jurisdiction because it's a boat, it's on water, but it turned out that lake had no connection to the navigable channels, and therefore in the maritime jurisdiction. I think actually ended up the case getting dismissed, so make sure you get that right sometime. But then the other case is this place in Louisiana. In Louisiana, as you get into the bayou, you get in these areas that can be really boggy and flat, and sometimes, like you said, dry at different parts of the year. And there was some kind of injury case off of a boat that ended up in one of these areas, way up in the bayou, kind of in the marsh. And while you couldn't necessarily just hop on a boat and scoot out, uninhibited to, out to the Mississippi and make your way out in the Gulf, but different times of the year, the waters were up to a point where you could. There was a channel for commerce between where this was, the once dry part of the basically land bog, fills with water, and then there's a way to get out to that shipping channel. And they said, well, no, that's navigable, and therefore there's maritime jurisdiction. So it's a pretty interesting setup.
It is. So, you get hurt on a boat in Augusta, Georgia, which is nowhere near the coast.
Right.
Well, that's on the Savannah River that can find your way to navigable shipping lanes.
Yeah, and I think that's when you're dealing with admiralty stuff. As I've gotten my head wrapped around it, I kind of want to zoom out and like, what is the point? And the point goes back to something you were talking about, is the powers that be, the sovereigns that allowed this law to be created and that continue to protect this specific area of law as its own thing, wanted to make sure that they protected shipping because it's an important part of an economy, commerce. So maritime jurisdiction is really all about protecting commercial transport of goods. And so one of the questions you ask about maritime jurisdiction is what impact would it have on commercial vessels moving through this area? Or what impact could it have? So not even limited to the specific accident, but it's like, well, maybe no cargo ships got held up or, no shipping lanes were blocked, but could it have? And if it could have, then again, good chance there's some maritime jurisdiction.
So what are some different types of maritime claims that are, we're dealing with injury mostly. You certainly have the more shipping-based, more contract-based, goods-based stuff, which is not really within our bailiwick. So what are some of the things that we see? I mean, you got Jones Act, of course.
Right. Jones Act covers seamen, people who make their living working on the water.
Right.
And there's a test, if a certain percentage of your job involves working on boats on the water, then you are a seaman. You may also work on land, but you work on water enough to be considered a seaman. And if you get injured, unlike workers' comp, that I don't know if most people are familiar with, but a lot of people are familiar with, you can, under the Jones Act, you can actually pursue your employer for negligent acts, including having an unsafe vessel. It's called a seaworthiness claim. If there's something about the vessel that you're serving on that was it maintained right or was dangerous, you can bring a negligence claim against the employer under the Jones Act. So that's one example. There's also the Death on the High Seas Act, which applies to anyone who is killed beyond the territorial limits. I think it's a 3-mile limit. Hold on.
Mm-hmm. That's right.
Typical, yeah.
Yeah. It'd be some sort of accident that results in death on the high seas. It's another one of those sort of lofty sounding, dramatic names.
Sounds like an Agatha Christie book,
Yeah. Death on the High Seas.
Death on the High Seas and Murder on the Orient Express.
Yeah, exactly. I talked just a little bit about some. I mentioned it, but if you've got a person who works for the federal government, and they hurt you, we talked about the FTCA claims, Federal Tort Claims Act cases. If it is something that happens within admiralty jurisdiction on a ship or in a port on a ship, it may not be an FTCA case, maybe what we call a suits and admiralty case, which acts a lot like the FTCA, but has a little bit different procedure to it. One of the most important ones for folks to be aware of is that in a Suits and Admiralty Act case, unlike the FTCA, when you file an administrative claim there, it does not toll the statute of limitations. So FTCA case, as long as you get the admin claim filed before the statute of limitations expires, that statute of limitations tolls. But in a Suits and Admiralty Act case, if you are in maritime jurisdiction and you file an FTCA, even an FTCA admin claim, you're not sure exactly where it lies, you need to keep an eye on the statute of limitations, because if it is an SIA case, then you need to file suit before the statute of limitations expires. And that's a really important thing to do.
And that goes to
That's a pitfall.
That's
Yes.
right. And there's a lot when it comes to maritime law that is just sometimes a little bit, sometimes a lot different than land law, you might say. Your normal law that most lawyers deal with. And so it's something that a lot of it in injury cases is actually more favorable to the plaintiff than you have on land. But there are definitely some landmines out there.
There's the Longshore and Harbor Workers Compensation Act. I think that I got all of that.
I think you did.
I hope so. My wife does a piece of that right now in her practice. But there is a form of, we call third-party claim there. So in the workers' comp, you can't sue your employer in court, but you get to go through this workers' comp regime, but you don't have to show fault.
Right.
You just show your injury, and there are limitations to that.
And the Longshoremen Harbor Workers Compensation Act is a federal
Right.
law which basically sets up a workers' compensation system for people working in and around the docks.
Right. And but if you are one of those dock workers and you go onto a ship, you may have a claim against the ship owner for a couple of specific areas. One is that they basically didn't make it a safe place for you to go. You go in and then you fall through the hole because it's rusted out, and they didn't have any barriers or up like that. You might have what they call a 905B claim, which is a claim against the third-party ship owner for the injuries that happen there. And that's another kind of a niche area of injury law that shows up in maritime jurisdiction.
Right. And what isn't quite maritime law because it's exclusive to the port, but you're talking about the longshoremen and the port workers, a lot of their claims, because it's a dangerous job, obviously, and they wind up suing in Georgia, the Georgia Port Authority, because say the Georgia Port Authority has the crane operator that has the big, container cranes, and if they, drop the crane on someone, or what happens sometimes is they try to lift it off the a trailer the chassis that the longshoreman's pulling, and then it's not undone yet. It's not unhooked, and it'll pull the truck up into the air, and then it finally comes down and drops everybody, and that happens really more often than you'd think, and people get badly hurt doing it. So there's, the longshoremen have unfortunately, they got jobs that you can get hurt at a lot of different places, but where they get hurt and how they get hurt, they got a variety of claims that they might be able to bring, and it's very fact specific.
Yeah. So I mean, you get hurt around the dock, a ship. You start just probably call a lawyer. Start there.
Right.
But some of the questions the lawyer is going to be asking is, okay, where exactly were you hurt? Where was the person when they hurt you?
Yeah.
So
it can make a difference how many feet you were from the water.
Yeah.
There's an interesting Southern District, again, back to the conference, looking at old, interesting Southern District cases. And, if you've got a tort where, say somebody throws a ball and hits you in the head, they weren't paying attention, so it was negligent. On land, no question. But if somebody did that from a beach and hit you on a boat, that actually it could potentially be an admiralty case because of where they hit you. Even though they were standing on the beach, they hit you while you were on that boat. That makes it an admiralty case. One of the reasons being is that person gets hit in the boat, and the boat floats out, then it gets in the way of a cargo ship, and then it gets in the way of the cargo ship, shuts down the country, and then everybody goes to war. All these things you have to worry about. But there's an interesting case in our district where everybody knows Union Bag or International Paper had a bunch of smoke coming out of the plant. I forget, it was a while, many years ago. But it basically blocked or caused obscured the vision of another ship, and that ship ran into a bridge because it couldn't see where it was going. And
Hazard to navigation.
Exactly. International Paper says, no, hey, this is an admiralty case. We're just here on the land doing this is not an admiralty jurisdiction. And the court said, no, even though the smoke was coming from land, it interfered with navigation, and therefore it was a maritime case.
All right. So I think anybody who's ever practiced any admiralty or maritime law has always been fascinated by another quirk of the law that allows you as a claimant to arrest a ship.
Oh, yeah.
I'm not sure I've talked to anyone who's ever done it. In fact,
I talked to two this morning.
Yeah.
Okay. All right. So in your seminar, I would like to hear the real world examples of someone arresting a ship. But talk about that. What does that mean?
Well, basically, it is what it sounds like. You can't put handcuffs on the ship. But I spoke this morning with a longtime admiralty practitioner, and he has actually done this several times. And it was in an era where it was more common. So to arrest a ship means you keep it from leaving port, and you're using that ship as security for the claim against the ship. So it could be security for an injury case. A lot of times it's security from some financial obligation that you defaulted on. But basically what it looks like is you file a complaint for whatever it is, default or for injury, and then you ask the court for a warrant on the ship, and the court issues the warrant, and then the marshal goes down to the dock and walks on the ship. And I learned this today. They would do it, they call it plastering the ship. And they literally take the complaint or the warrant and plaster it to the ship's wheel so that you can't move the ship because you got all this paper all over it. And that's what arresting a ship apparently looks like in real life. I've not done it, but I heard that story this morning, and I was like, tell me some stories about ship arrests.
So why is it less common now than it was previously?
My understanding is that you get a lot more insurance companies putting up security. So there's an option to do that where if there's a claim against the ship and there's a threat of an arrest or a warrant that goes out, oftentimes there's a negotiation with the lawyers involved. And instead of stopping the ship from leaving port and taking all of its cargo and making the money that they were expecting to make, they don't want it stuck at port. So they will put up some type of security bond, or I'm trying to remember the exact term, a letter of undertaking from a P&I club, which is a group of folks typically on the shipper commercial carrier side who get together and kind of pool for risks, and will say, no, let that ship go. our club or our insurance policy will have an undertaking to ensure, whatever obligation is that you say is owed. It's interesting. It's fascinating. So.
Yeah. It would still be fun to arrest a ship.
Yeah.
Yeah, I think that's a bucket
We should really
list.
arrest the ship sometime.
Yeah, that's a bucket list item. I wonder, I don't know this, but if you can refuse, I don't think you can, but what if you could? You say, no, I don't want your letter of undertaking. I want to arrest the ship. So
Good question. But I guess what's the point if you're just trying to get the money put aside? I mean, that was,
to arrest the ship.
well, that's a good point. I mean, if nothing else, I got like a canoe. We can just go arrest the canoe if we can't find anything else.
Yes, some boats my boats have found themselves arrested already.
Right.
Which kind of goes to, we've been talking a lot about commercial injuries, which are, the most common maritime claims, but it's not limited to, being a professional seaman or a dock worker or something like that. If you get in a boating accident out on the river on the
Right.
weekend, you are subject to maritime jurisdiction. And that can be both good and bad.
Right. Well, one of the things that makes these commercial cases more effective for plaintiffs is the availability of insurance.
Right.
And it's just not as prevalent, I think, in the recreational space. Although that, depending on the boat, or some of these clubs that are coming out these days with, where you have a membership and you get to pick your boat, they tend to have different policies that are there.
But without the policy, you may have a limitation of liability to the value of the vessel.
Right. Well, you talk a little bit more about that. I mean, that's a big part of admiralty practice, especially on the defense side, but it affects the persons that are injured. I mean, what happens in a limitation of liability case?
Well, they can limit how much the plaintiffs can recover by the total value of the vessels involved.
Right.
And so, and it's the total value of the two vessels. It's not just necessarily the wrongdoer. For instance, the ship where the John S. McCain ran into, got in a collision with a maritime ship. I can't remember the ship's name. The value of the McCain, which is a Navy destroyer, was a lot. It was a very valuable ship, and the value of the other ship was not as much. Well, the McCain was found to be more at fault than the shipping company or the freighter.
Vessel,
Yeah, and so it was something like, I forget, it was like 90% to the McCain, 10% to the other vessel. But the recovery for the sailors in the McCain, even though the McCain was mostly liable, was limited to the value of both ships, and that was still 10% of the value of the McCain and the other ship was still a lot of money to be spread around, which is sort of a strange way to do things. Even though that one ship had not much liability in it, the sailors could still recover against that ship. So it's an interesting, complicated area that's unlike anything else.
Right. I mean, in a trucking case or something like that, you don't have. Well, let me back up a little bit. So what we're talking about here is the Limitation of Liability Act, which is one of those few rare times when Congress intervened in admiralty jurisdiction, mostly to try to limit liability and putatively reduce the cost of shipping goods and things like that. And by allowing a vessel owner, if they're involved in some type of incident, to run to court first, instead of being the one to get sued, they actually go to court first, file a Limitation of Liability Act, which starts this procedure in which it's kind of like bankruptcy, where basically they say, hey, our ship is worth, let's just take the Key Bridge.
Yeah.
Right. The bridge disaster in Baltimore.
Right.
Because this actually happened.
This is happening now.
Yeah.
Yeah. I mean, at least at the time of recording. And one of the first things that happened is the ship owner, I think Grace was one of them, and the Dali is the vessel, ran to the court there and filed a limitation of liability action. They actually sue everyone they think that might have a claim. So the city of Baltimore, the state of Maryland, all of the folks that were working on the bridge when it collapsed, some of whom were died. And then if you Google in the news right now, the Justice Department's looking for $100 million. So these people are looking for $100 million. It's a lot, but they have claimed that the value of the vessel less the cost of salvage is, I think, in the maybe 80 million. I don't have the number in front of me, but it's far, far less than some of these headline numbers that are being sought in lawsuits. And it's going to be the job of the court to do kind of like a bankruptcy judge would and figure out, okay, how are these claims going to get resolved given that the pot of money is so small. Andrew, at one time we were entertaining a jet ski case.
Right.
And I don't know, we little bit about the livery in that case, which it's one of the admiralty law does this. Or just pulls these sort of weird archaic
Right.
issues up. All of a sudden, you get this case that happened on a jet ski in 2023 or whatever, and all of a sudden you're talking about livery. I mean, do you want to talk a little bit about how that worked, or would it look like it might work? Generally, he doesn't want to do it. I don't know. I'll take. Basically, the livery stable, we go rent a horse. So this is like that jet ski rental company gives a jet ski rental. They have certain obligations to the person that rents the jet ski. If they don't do what they were supposed to, prepare you, and are available for your assistance, then they can be liable. And that's what a livery case looks like.
Okay.
Interesting stuff. Maritime law.
It is interesting stuff.
All right, Stephen. How did the hamburger introduce his new girlfriend?
It's nice to meet you.
Meet Patty.
And on that note, thanks for tuning in to Justice for Y'all. We'll see you next time. Bye.
Thanks for listening to Justice for Y'all, hosted by the attorneys here at Bowen Painter Trial Lawyers in Savannah, Georgia. If today's episode resonated with you, or if you find yourself needing legal guidance, remember, we're just a call away. You don't have to work through the difficulties of your situation alone. Visit our website at bowenpainter.com, that's BOWENPAINTER.com, or give us a call at 912-335-1909. We're here to serve you with the dedication and warmth only true Southern hospitality can offer. Thanks for tuning in, and don't forget to subscribe to our podcast on your favorite platform so you don't miss an episode. And tell your friends and family about us if they're ever in need of some legal insight. Take care, and remember that at Bowen Painter Trial Lawyers, we're committed to justice for y'all.